Hello, everybody. Welcome to the fifth edition of Talk Death. Who owns your body? Funeral Law and Rights, the American edition this time. And today we are with Tanya Marsh and Lee Webster. Hello, Tanya. Hello, Lee. Kate Pearson on our blog is asking, my wife is Jewish, but she wants to be cremated. Her family is very against the idea. If she died, what sort of legal protection would she have? Maybe Tanya, do you want to try to tell us more about this one?
Sure. So at common law, meaning judge-made law, the law we inherited, both Canada and the United States inherited from England, the deceased has a right to determine the place and manner of disposition of their own remains. That's a common law right. There's cases in the United States this year that reiterate that right. In modern times, though, we also have state statutes that in some ways constrain that and in some ways give guidance to it. So not every state, most states have a statute that says this is the order of control or order of priority of control of disposition of body and who can make decisions. In states that have that, sometimes the decedent is at the top of the list, so they can leave binding written instructions in various ways that's dictated by state law. Sometimes they can appoint a particular person, a designated agent, to make those decisions for them. Sometimes the law says if you pay for everything in advance and have a pre-need contract with a funeral director, then that's going to be honored, and the state will make sure that's honored. But next in priority, even without all those other things, is going to be the spouse. Spouse is always going to have priority in every single state in the country. Spouse has priority over parents, children, siblings, best friend, everybody. The only person who can trump a spouse is the decedent themselves, and that's not even true in every state.
So what can someone do to ensure that their wishes are honored?
They have to find out what the law is in their particular state with respect to this, because this is a very technical area and details matter a lot. There was a case in Iowa just a couple of years ago, I think a very sad case, about a woman who had been living in New Mexico, and she was separated from her husband, not legally divorced. She and her husband had 10 children. This is the Florence Waylon case, if you're familiar with it. She had written a will and said she wanted to be buried in Montana. They'd lived most of their adult life in Billings. She had pre-purchased a casket from some Trappist monks, and so it's in her will. She did everything in accordance with New Mexico law. She goes back to Iowa, where her husband was living, to visit some of their children, finds out she has terminal cancer, never goes back to New Mexico. And so when she died, her sister, all 10 children, went to the funeral director and said, "These are our mother's wishes." Her husband went in and said, no, I want her to be buried in this local cemetery. And she had to sit in a refrigerator at the funeral home until the Iowa Supreme Court said that even though she had done all of that in accordance with New Mexico state law, she died in Iowa, and it wasn't in accordance with Iowa state law, and therefore her husband got to trump what everybody agreed were her clearly stated wishes. So this is something that you can't mess around with. You have to make sure you know. I mean, we can't control, unless we stay at home forever, we can't control where we die, right? So there's always going to be sort of an element of uncertainty there. But at least with respect to your home state, you should know what the rules are and make sure that you follow them.
So if I'm not mistaken, what you're saying is that if you live in Iowa and you have a will in Iowa, or even if you've bought a plot of land at a cemetery in Iowa, but you die in California, you're not necessarily under Iowa regulation anymore.
So if I'm a resident, I'm a resident of the state of Indiana. I know I teach in North Carolina. Let's not even talk about that. So I'm a resident of the state of Indiana. So my will, if I die, as long as I'm a resident of the state of Indiana, will be interpreted under Indiana state law. It doesn't matter where I die. So that's sort of a reciprocity agreement that all the states have amongst one another. They do not have the same reciprocity agreement with respect to disposition of human remains. So what that means is the way all the statutes are written is they apply to all remains that are in that state, right? So if I die, wherever I die, it's the law of that state that dictates what happens to me. Now, in the Iowa case, it was a little fuzzy because she'd been in Iowa for 6 months. And so the court kind of said, well, you know, we think maybe she was a resident of Iowa again and not a resident of New Mexico anymore. But that wasn't part of their decision. And who would know that anyway, right? In fact, I've looked for this because this is a really strange thing in the law, and there's not a single case in the United States that says that a state will recognize the disposition laws of another state in the same way they would respect their wills law, for example. So maybe you can get away with things. It depends on, does everybody agree, and what's the funeral director sympathetic, etc. But technically, push comes to shove, the courts are going to enforce the laws of the state you died in.
Interesting. That's super complicated and nuanced. It almost, I don't know, it's not super comforting, but as long as you sort of write it out and have it straight for your state, then you should
Full
be
employment for lawyers.
But luckily for Mr. Pearson, who asked the question, seeing as you are her husband, you do have that final say. So if you respect her wishes, then she will get them. So that's at least good to know on that end.
So long as she dies in the state that she lives in.
No, but she just mentioned that, right? I think so. Even if she dies in another state, then he would have the right because he's her spouse.
Yeah, in every state, the spouse is going to trump everybody else. But
exactly.
With respect to that question and any others, I can't tell you what the legal answer is in all 50 states. I'm only licensed to practice in the state of Indiana, and so even though I've read all the laws, and Lee's read all these laws as well, but you really need to talk. This is too important. You have to go talk to a lawyer in your own state and make sure you understand what the rules are.
Okay.
Yeah, and I would add that you want to be sure that part of what we're talking about here is advance directives. And one of the things that people don't understand about advance directives is that they don't really have anything to do with funeral planning.
Right.
So, you know, an advance directive, a durable power of attorney for health care ends when the person dies. And the durable power for finance isn't really just going to pick up where they left off. If you haven't left your plans and told people what it is that you really want, and then hope that all these other pieces that Tanya's talking about fall into place, then you're out of luck. So,
and worse than that, Lee, those proxies, healthcare proxies, etc., those are reciprocal. The states will respect them, and many states, in fact, promulgate as part of their form for these healthcare proxies, what do you want to happen with your funeral? That isn't even enforceable in those states because it contradicts the other statutes that talk about disposition priority. So even within state statutes in a single state, they are internally inconsistent, but at the end of the day, the disposition statutes are going to control over whatever that proxy says. So those are the ones you need to make sure you look at.
Right, and make sure you have real conversations with the people who are going to be in charge, because that's what's going to matter.
That's the most important, absolutely.
Right.